Good morning and welcome to CPSC's sponsored webinar, Document It or It Didn't Happen. Fire officers face more problematic legal issues in today's work environment than ever before. Today we will hear from Envisage Technologies legal counsel Gerry Roberts about how the documentation you may be doing to achieve accreditation can also improve your legal defensibility. Gerry Roberts, JD, is a member of the Indiana Bar and has served as an administrative law judge. He has worked at the Indiana Office of the Attorney General, the Denton County District Attorney Office in Texas, and the Dallas Public Defender's Office. An acclaimed writer regarding legal concerns for public safety, Gerry has published several articles and white papers. He currently serves as the legal counsel for Envisage. At the end of the webinar, please contact Envisage Technologies directly for additional information and be sure to visit their booth at the 2020 Excellence Conference, March 3rd through 6th at the Caribe Royale and Convention Center in Orlando, Florida. Gerry, you can now begin the webinar.
All right, thanks, Cindy, and good morning to everyone. Thank you all for attending today's session. It's an honor to be presenting today's topic for you all, Document It or It Didn't Happen, to highlight the important role that documentation can play not only in your accreditation processes, but also in improving legal defensibility for both your department and your personnel. As we go through today's webinar, I wanted to remind you that you can submit questions using the chat feature of GoToWebinar. My colleague Kim Storvik is on hand to help answer some of these questions as we go along, and to collect the others for whatever Q&A time we have remaining at the end of the session. As we're dealing with questions that may have legal implications though, and I cannot give actual legal advice to you in this forum, I would just ask that questions be mindful of that fact and be phrased with as little specificity as possible about your situation. Of course, I have to include that note because we live in a litigious society where the looming threat of litigation is always just around the corner. So whether you're an attorney delivering a webinar or an administrator at your fire agency, it's important to always understand where your exposure is and how you can proactively manage it. To do that, we're going to touch on 5 topics today. We're going to survey the litigation landscape, getting a feel for potential exposure and a sense of our greatest threats. Then, we're going to answer some very important questions about defenses and immunities, how lawyers attack them, and how documentation can be used as a preemptive counter against these tactics. We'll discuss the elements of good documentation and, most importantly, how we can ensure that our documentation is actually admissible in an administrative or a legal setting. Finally, we'll learn how documentation standards translate to work you may already be doing for accreditation, and what happens if you aren't meeting these standards. In essence, all lawsuits are essentially about the same thing: loss recovery. Whether we're talking about the loss of a job, an opportunity, money, property, or even a life. So it should come as little surprise that a profession like yours, which is tasked with responding to emergencies and preventing great loss, faces some of the highest litigation risks. However, what may surprise you is where these lawsuits are coming from. Is it from damaged real estate and structure fires? From massive wildfires destroying entire communities? Property damage or wrongful death from uncontrolled or mismanaged fires? Or perhaps the greatest risk firefighters face is from the rescue and EMS side of their duties for failing to save a life or committing emergency medical malpractice. Surprisingly, the answer is none of these. Kurt Verone maintains the Fire Service Litigation Database, and of the roughly 3,000 civil cases filed through July 2017, the majority are actually employment-related lawsuits, which are filed by or on behalf of employees or job applicants. Mostly these are discrimination, but also promotions, hiring, demotions. Therefore, statistically speaking at least, you probably already know the next person that's going to sue you. When these are subtracted from the mix, however, the primary exposure comes from the type of training and policy issues that we're going to talk about today. But regardless of whether a lawsuit is coming from within an organization or outside of it, one constant is going to be the importance of documentation. And so, even though our focus today is on how departments can improve documentation around compliance and training for knowledge and skills and abilities to help improve their legal defensibility, many of these concepts can be applied across your organization to reduce other sources of liability. With the NFPA reporting more than 1 million fires in the United States last year alone, you may be mildly, even pleasantly surprised to hear that there have only been a few thousand civil cases involving fire departments in recent decades. This is despite more than 50,000 injuries to firefighters sustained each year, roughly half of which are in the line of duty, and more than 15,000 emergency response vehicle collisions a year. However, this is no small problem because even a single failure to train lawsuit is capable of resulting in, for example, a $1.6 million verdict. So with the potential for very large verdicts, the large number of annual incidents, and a growing sort of litigiousness amongst the population, why aren't there more lawsuits then? The reason has to do with various layers of legal immunity. As it turns out, fire departments and their personnel are largely shielded from any legal liability due to a variety of protections. In the Constitution, for example, the 11th Amendment provides states with sovereign immunity, which protects them entirely from suits by certain types of litigants. There also exists the concept of qualified immunity in the application of some federal laws. Basically, it holds that any discretionary acts performed in the line of duty, discretionary acts are those split-second judgment calls on what action or inaction you should take, those cannot be used as a basis for a civil suit. And importantly for departments, if individuals have qualified immunity for their conduct, so do their employers for actions resulting from that same conduct. This is separate and distinct from the concept of absolute immunity, which is typically reserved for positions like judges or prosecutors that essentially have no liability for official actions taken within their scope of duty whatsoever. However, some states have extended absolute immunity type protections for certain firefighter conduct, such as the state of Illinois grants absolute immunity for failure to protect the public, the failure to suppress a fire, the failure to save a trapped person, the failure to intervene, or any accidents which have been sustained from the operation of a vehicle or emergency equipment when responding to an emergency. State laws also will regularly indemnify or take responsibility for individual firefighters that are sued for any acts that they took in the line of duty. This can be in the form of providing legal counsel or paying for damages, or even dismissing the personnel from the suit entirely in their individual capacity. There's also the concept of deep pockets in litigation. Have you heard that one? Where you seldom go after the individuals, you try to take it up the line, because as they say, you can't squeeze blood from a turnip, and most people don't have the kind of cash around to recover your house losses. With all of these protections and immunities in place then, you may be wondering how we actually get to that 3,000 number mentioned before. The answer is that for each immunity and defense out there, legal theories and tactics exist to fit between or outside those lines. And these attack vectors are the primary source of litigation exposure for fire departments. For the 11th Amendment's sovereign immunity, It's worth noting that states can, and often do, waive their right to avoid lawsuits. Sometimes they do it intentionally to share the risk of certain conduct across its population. Sometimes they do it for other equitable reasons. Sometimes they even do it unintentionally. They waive it in the way that they do business. But even if waiver doesn't fit the situation, the immunity typically doesn't apply to political subdivisions, like municipalities or their fire departments. Insurance companies may also find ways to bypass protections, 11th Amendment or otherwise, through contract law, arguing that the insurance company needs to be reimbursed for paid claims on the basis that you haven't upheld standards in the insurance agreement. It may go without saying, but the Constitution also does not protect those in other legal systems. In Canada, for instance, municipalities can be liable for damages resulting from the negligence of firefighters and their equipment, which is a slight departure from the default American rules. As its name would imply, qualified immunity, which again, remember, is for those discretionary acts performed in the line of duty, is not an absolute immunity. And the legal context to which qualified immunity applies, so-called Section 1983 lawsuits, provides a roadmap for how to successfully sue government actors. These Section 1983 lawsuits are a huge source of liability for cities and comprise roughly 40% of civil cases against firefighters. This federal law provides that individuals can sue the government when clearly established constitutional rights have been violated under color of law, which for our purposes roughly means that they were acting with government authority. However, a single rogue or reckless employee is usually not enough to make the department itself liable under the law. Rather, a department only becomes liable for constitutional violations if there's a pattern of misconduct or a deliberate indifference to constitutional rights. And these are typically reflected in a department's customs, its policies, or its training. The question then isn't whether or how someone's rights got violated, but rather why it happened, if it's happened before, and whether your practices make it likely to happen again. Even absolute immunity isn't as protective as it would seem. In the Illinois state laws mentioned, firefighters have no liability for certain kinds of conduct, but the statutes still have carve-outs for things like reckless or intentional acts. This makes some sense, otherwise a firefighter with a vendetta and a fire engine could destroy anything on his way to an emergency. But this kind of undermines the fabric of what absolute immunity is, right? Likewise, there may be complete immunity for failure to save a trapped person in a fire if they die, but if you read the fine print, the immunity may not attach if you attempt to save a person, succeed, but injure them. Now, please don't take that to mean that avoiding a dangerous extraction is better than attempting it, but it's important to understand that there are different legal standards that are going to apply to your conduct. What this all means is that even with these immunities, cases are still filed and contested, but they often focus on different aspects of the case than you may expect. Rather than focusing on whether conduct was negligent, the focus becomes on whether it was reckless and intentional. Rather than focusing on whether someone died due to avoidable circumstances, the question becomes whether volunteer firefighters qualify for the same immunities as paid employees. And rather than focusing on what constitutional rights were violated, the focus often becomes about policy and about training. Regardless of the attack vector used to sort of cut past an immunity and open a case, a central theme here is that attorneys will break past the shield and achieve the favorable outcome they're looking for by leveraging unreliable or conflicting statements. Nothing, and I mean nothing, plays out worse for credibility in a courtroom before a judge or a jury then hearing witness testimony contradict another witness, contradict a document, or contradict your own statements. Whether you're being interviewed, deposed, or cross-examined, everything you say is being recorded and cross-referenced against all other materials in a case, and you need to prepare for that accordingly. So, how do we keep our shield intact? Through a combination of good policies, good training, and maybe most importantly, good documentation thereof. Whether we're dealing with failure to train or another violation of constitutional rights under Section 1983, or not upholding a standard of reasonable care in a negligence case, documentation is going to play a key role. If an incident occurs and your records can't prove what your policies were at the time of the incident, they can't prove the content of your training, whether someone attended the training, whether the employee acknowledged a policy, or whether an employee's certification or training were valid at the time, then you will have tremendous difficulty defending yourself in a lawsuit. Even if your policies and training are still good, the lack of documentation will lead to problems getting your evidence admitted, a high probability of inconsistent statements if you do get it admitted, or worse, charges of spoliation if you don't have the records altogether. Alternatively, if your documentation can show that your policies and training were up to date, administered, and understood, you go a long way to establishing that, at least at the organizational level, you have upheld your standard of care and not been deliberately indifferent to others' rights. Even if your personnel have clearly done something wrong, remember that a large percentage of cases, nearly 40%, are brought under Section 1983. And these claims require a showing that a policy or custom at your department is to blame for the underlying incident, not just a bad employee. If you have documentation showing that your employee was not acting within the scope of their training and their policy, you establish an affirmative defense to liability that's nearly impossible to overcome. Unsurprisingly then, we hear these sort of sentiments echoed over and over across the entire industry. Fire engineering, for one, says that prevention and documentation are the best defenses. Documentation should be in the form of a training record for the training officer to determine the instructor's competency to train and to record the training events for individual employees as the training occurs. Another fire engineering article notes that the most important qualities of training are that training needs to be verifiable, realistic, and ongoing. Again, noting that important role that documentation plays. Well-respected thought leader Gordon Graham has also noted that reports need to be consistent with policy and complete. And he stresses the importance of using this documentation to jog your recall memory, to use that as an affirmative defense in the courtroom. So when we distill this wisdom, what exactly does good documentation look like? Essentially, you need to be able to prove not only that your training and policies are current, relevant, and taught by appropriate personnel, but that your personnel actually received and understood that version of the training. Because of evidentiary concerns, though, these records need to be created and maintained in a very specific way if you want to use them in the courtroom. The federal rules of evidence, which are adapted or adopted in some fashion by nearly every jurisdiction in the country, come into play here. And they essentially require a legally defensible training record to have three characteristics. Records need to be regularly created, timely stored, and securely maintained. Why? Under Rule 901, an item cannot be admitted into evidence unless you can prove that it is what it purports to be. In other words, to use your training reports or policies as an affirmative defense, you need to be able to prove that it is an authentic representation of the underlying events. How do we lay a proper foundation and do that? Well, if a witness has personal knowledge of the training and the record, then they can testify in court to that end. However, bear in mind that the statute of limitations for Section 1983 claims can be as long as 6 years, not including the length of the litigation itself, which, as we all know, can take several more years. The average career firefighter has a tenure from a high of about 20 years to about 5 years now. So there's a chance that nobody within your organization is going to have that personal knowledge of the training or the training records. If you do have someone with personal knowledge of the training to testify about the records, again, bear in mind our natural tendency to vary our answers upon repeated questioning over time and the adverse impact that this can have on credibility. If you clear that hurdle and you have someone with a mind like a steel trap that gives true and reliable testimony time and time again, you still need to be able to prove that the records are authentic. And if you keep your training records in a box on the shelf or in an Excel file shared with everyone on your server, it's difficult to prove that the record wasn't just created or entered yesterday. Thankfully, authentication of evidence doesn't necessarily require personal knowledge of the event if you have a reliable process that you use to collect training records. All you need is a custodian of the records to demonstrate subsection 9 here, that your processes and your systems produce an accurate result. Part of that is being able to show that sort of chain of custody or audit trail so that there's no question about the integrity of the data. Once you clear that hurdle, attorneys are still likely to object to the introduction of training records as hearsay. Well, what is hearsay? It is an out-of-court statement or record which is being offered in the courtroom to prove something. The general rule is that hearsay is always inadmissible, except when it isn't. The federal rules of evidence spell out several exceptions, the most relevant of which is 803 subsection 6, which is records of regularly conducted activity. If you regularly record your training records at or near the time of the underlying training event, it is no longer hearsay. However, if you only record your training occasionally, or it takes you months to enter the data into your records management system, an attorney is going to make the argument that it should not be admitted. So, think about your day-to-day handling of records. For those of you wondering whether your current processes and systems meet the sort of standards that we're talking about, know this: judges are human, and if there's any doubt about the integrity of your data, some of them are going to rule against your records being allowed into evidence. When that happens, Rule 103 makes it nearly impossible to reverse that decision with an appeal. Thus, even with great training and perfect policies, the lack of documentation can undermine your ability to present evidence, and your case simply falls apart. From a legal perspective, then, make sure that you keep your policies and training up to date and document everything. If your documents are secure and are both created and stored as part of your regular workflow, you can sleep at night without worrying about your liability. Again, records need to be regularly created, quickly stored, and securely maintained. Now, given the close relationship between good policy and good documentation, it shouldn't be surprising to hear that these same standards are often tied to various accreditation standards. Therefore, if you are seeking or maintaining these accreditations, you'll find that time spent improving your documentation practices will pay both immediate and long-term dividends. Perhaps more interesting for our discussion today is why these standards should matter to those agencies that aren't pursuing accreditation. Negligence claims, they represent over 30% of all cases filed against fire departments. And for those of you keeping score at home with the percentages, remember that lawsuits can allege multiple causes of action. And one of the core tenets of a negligence suit is being able to demonstrate that someone owed you a duty of care and breached that duty. Depending on the situation, this requires proof either that they violated what a reasonable person would do in that situation, or, in the case of professionals like yourselves, that you failed to live up to the standards commonly held in the profession. Therefore, regardless of whether your department is accredited, attorneys will always try to tie standards of reasonableness back to industry standards. Where have industry standards been codified and adopted? By accrediting bodies, right? In the courtroom, it works something like this. Oh, your company took 9 minutes to travel to a structure fire? Are you familiar with NFPA 1710? Let me get an expert to testify about the role of NFPA in the fire industry. If you didn't know, NFPA 1710 says that you need to be able to respond to a fire in 4 minutes or less. So now we're going to try to sue you for the damage done in those extra 5 minutes. Therefore, it's important to understand not only that the work you're doing for accreditation may have general applicability for defending a lawsuit, but that failure to adhere to accreditation standards are often presented and sometimes interpreted as a base for performance and reasonableness in negligence suits. So what documentation standards should departments be mindful of? The regulations and standards are all across the board, as I'm sure you know. OSHA 1910-156, for example, requires not only personal protective equipment as a workplace safety measure, but also requires annual training about the equipment and, importantly, documentation thereof. For ISO ratings, you may already know that fire departments are responsible for about half of the rating points when they grade municipalities. ISO looks at annual training requirements for your company, certifications, what you do for driver operators and hazmats and recruits, and all of these things require documentation for ISO. For those of you who are involved with Pro Board or IFSAC accreditations, IFSAC says that the entity shall provide documentation indicating that the entity meets or exceeds applicable NFPA safety and health standards or their equivalents. The entity shall have written procedures for conducting evaluator training to include evaluation, policies, and the record-keeping process. Meanwhile, Pro Board goes into a little more detail, and they require documentation and demonstration of things like testing to NFPA standards. What are your procedures for test development, administration, review, and improvement processes? What are your procedures for test banks, versioning, and randomization of questions? And what are your procedures for evaluating and selecting testing administrators? Again, regardless of whether or not your state or even your department have adopted NFPA or OSHA or these other standards, you must be mindful of the standards reiterated there, as others, a judge, a jury, or plaintiff, may expect them of you nonetheless. Documentation standards apply to NFPA standards like 1041 for instructor qualification, 1403 for live fire training, 1500 for occupational safety, and most important to our discussion today, 1401. NFPA 1401 sets the recommended practice for fire service training reports and records. So I've laid out a top 10 of how training records, policies, and systems should be approached to maximize your legal defensibility. Reinforcing the entire theme of today's webinar, number 1 provides that training records and reports are becoming more important for use as evidence in public liability suits brought against the organization's fireground activities. Number 2 echoes that and says training documents, regardless of their intent or level of sophistication, should focus on content, accuracy, and clarity. Number 3, a concern of the fire service is the threat of litigation. The maintenance of, and here we go again, accurate and complete training records in accordance with this document, again referencing itself, is one of the ways fire departments can limit their liability. That's NFPA telling you that if you follow our standards, you limit your liability. Accurate and complete training records are also required by a number of different laws and standards. They don't mention it here, but we're talking about OSHA, we're talking about ISO, we're talking about state laws. Number 4, the number of training records should be kept at a minimum to avoid confusion and duplication of effort. This is them telling you that you need to focus on quality, completeness, and timeliness of records, not necessarily the quantity of records, right? We have to be smart about it. Number 5, all training records and the record-keeping system should be evaluated at least annually. That means you don't have to look at every single training record every year, but you must be sure to evaluate your processes and record-keeping systems regularly, because best practices and standards are constantly evolving, and you need to make sure that it fits. Number 6, most training records should be maintained in their entirety in a computerized form, thus greatly reducing the amount of paper that needs to be stored. This isn't just the NFPA being green. It's about advocating an approach for efficiency and reliability in both storing and accessing your records at the moment you need them. Number 7, the computer has the potential for eliminating many, if not all, of the problems associated with a manual record-keeping system. Before spending the time, effort, and money needed to develop a program, commercially available alternatives should be evaluated. The bottom line here is that it is expensive to develop your own software, and solutions exist that can do much more with a much smaller investment. Number 8, minimum information for state certification records should include a single file that includes all training accomplished by the individual firefighter during his or her career. This is the NFPA saying that a firefighter's shoebox of diplomas should not be the defining training record for your employees. These statewide records should also include dates, hours, locations, and instructors of all special courses or seminars attended, and monthly summaries of departmental training. Number 9, fire service organizations should be able to document clearly both internally and externally obtained career development training and education. And number 10, they go into some of the reports that you should be able to produce. They mention a complete inventory of apparatus and equipment, detailed plans for training improvements, detailed periodic reports on evaluation and training for probationary firefighters, monthly summaries, an annual report of the training division, and a complete inventory of training aids and reference materials that are used by your department training. Can you produce all of these today? If you can't make them today, then you can't use them tomorrow in a lawsuit when you need them. If any of this sounds or has been overwhelming for your department, it's important to understand that there are very tangible benefits that can be realized by having these practices. And number 2, that there are solutions out there that can make this much easier for you. Envisage, today's webinar sponsor, produces both enterprise-level software in Accreditation and department-focused software in First Forward, which have been specifically designed for the operational, security, and legal defensibility needs of fire agencies like yours. And for the budget-conscious folks out there, with First Forward, you can start managing things like training records and exposures for free. Recapping what we've learned today, I want you all to feel confident that we've touched on all 6 of the goals listed on your screen. For number 1, we talked about how most lawsuits are employment related, but that Section 1983 and negligence lawsuits have a substantial impact on individual departments. For number 2, we discussed various types of immunities: sovereign, qualified, absolute, statutory, and found that questions of policy, training, and documentation were often at the core of cases that actually get filed. For number 3, good documentation needs to be admissible and helpful to you. So it should be complete, concise, regularly created, secure, and timely stored. When your documentation is created in this way, it can be used as an affirmative defense against attacks on your departmental policies and customs, and ensures that your testimony doesn't waver or get undermined by a plaintiff's attorney. For number 5, we discussed how accreditation standards are often tied to negligence cases, and that good documentation is often at the core of these standards. And last but not least, we learned that NFPA 1401 has specific recommendations for how we should manage our records, and that systems like Accreditation and First Forward have been designed to make it easier for department to meet these goals. With that, I'd like to thank everyone again for their time today and open up the floor for any remaining questions.
Okay, I've got a couple questions here. How would a fire department violate someone's constitutional rights?
That is a great question, and I don't take that to mean that you're trying to violate somebody's rights, but rather when we're talking about Section 1983 lawsuits, which depend on violating constitutional rights, what rights would a fire department be violating? And a lot of times when we're thinking about constitutional rights, our mind goes straight to things like free speech or the right to bear arms. But there's so many other rights wrapped up in the Constitution. And the one that fire departments most often get tripped up on for Section 1983 lawsuits is the due process clause of the Fifth Amendment protects things like life, liberty, and property. And it applies to states as well through the 14th Amendment. And so anytime that you are destroying property or depriving somebody of life through an injury or death, those are the sorts of things where you invoke constitutional protections. And so that's where constitutional rights sort of get wrapped into fire department litigation.
Okay, and then I have one more. You mentioned the lack of documentation could be viewed as spoliation. Can you explain that?
Yeah, I just sort of mentioned that in passing, but I should probably spend some more time there. Spoliation, the old rule of spoliation says that the intentional destruction of evidence permits an inference that the evidence would have been bad for you. So if you have evidence in your hand and then you destroy it before a case comes along, the jury is instructed that, hey, they probably destroyed it because it was really bad for you. Now, the old standard on spoliation was that you had to destroy the evidence intentionally. But we're seeing a trend now with spoliation where it's not just intentional destruction of records, it can be reckless destruction of records. And so you could have records in your property that you lose track of them and then you've recklessly misplaced them and you should have had them and it would have been helpful to a plaintiff. We've seen some people take that one step further and say that, it's not even just reckless, it's just negligent conduct that can sort of invoke this. And so we see this trend of intentionality now to negligence, where there are causes of action emerging out there where the failure to create a record, especially when national standards like NFPA say that you need to have these kinds of records, the failure to create that record in the first place might itself be construed as spoliation in a case. So if we're looking for emerging areas, emerging things to watch out for in the fire industry, not creating records the way that NFPA says that we should is probably going to be one of those things that comes out. And so when you have destroyed records or not created them in the first place, the first thing that happens is the jury gets instructed that it would have been bad for you. Some states, though, have made that a tort. So an independent basis for a lawsuit is, hey, you should have had records and you don't have them, regardless of the underlying action. And we see some places that have actually made spoliation of records a crime. It depends on the context of it, but destroying records is usually not a good thing. So.
Okay, so that's it for questions. I'd like to thank you, Gerry, so much. This was a great webinar. It has been recorded, everybody, and I will be sending the link to Envisage and an email out to you all on how you can obtain this, so you can show it at your own department. And of course, you can always email me if you have any questions. So thank you all so much for attending. And thanks again, Gerry and Kim, who's in the back. Thank you so much.
Thanks, Cindy.
Okay, you all have a great day.